Good afternoon, everyone. My name is Mari Pao Paz, and I am a 3L here at Berkeley Law. Thank you so much for coming to the Structural Change panel. This panel is going to be all about the ideas and visions that we can have for how the RJA can make the biggest impact for the greatest amount of people. We have a wonderful panel in front of us. I'm going to do just quick introductions, but if you would like to learn more about any of the panelists, all of the information is on the QR code that you scanned. First person we have is MacLean from ACLU of Northern California. Emmy is a senior staff attorney for the Criminal Justice Program at ACLU NorCal, and she focuses on criminal justice litigation. As a part of her work, she's helping coordinate an effort to access prosecutorial information across the state for the purpose of the implementation of the California Racial Justice Act. We also have Kuluk from the Contra Costa County Public Defender's Office. Evan is a felony trial attorney with the Contra Costa office. He has been a deputy public defender for the past 16 years, and he serves on the board of the California Public Defender Association. And last but not least, we have Sean Garcia-Leys, who is a civil rights attorney and public safety advocate who works to end law enforcement's counterproductive gang suppression strategies and to support a robust implementation of the California Racial Justice Act. He is also the co-executive director of the Peace and Justice Law Center in Orange County, California. Thank you so much for being here, and we can go ahead and get started with Emmy.
What an amazing day and what an incredible gathering of people. I will say the title of our panel feels a bit daunting, structural change, but that is, of course, what we're all aiming to achieve from different vantage points. What brings us here in large numbers, besides the lovely Berkeley weather, is the shared sense that we have the potential for something grand, and we have the obligation to ensure that the RJA achieves its stated intent to unravel an unjust system. The California legislature in the RJA's preamble presents clearly the law's bold ambitions: to eradicate racial disparities in the criminal legal system, to provide remedies, and to ensure access to all relevant evidence to do so. Sadly, we're not all gathered here 3 years later to bask in the glow of having eradicated racial disparities in the criminal legal system in California to celebrate the dawn of a new era. We are here to better understand the challenges in trying to do so, to learn from our efforts to overcome them, and to figure out how this law can achieve its potential. There is a stunningly small number of RJA victories in courtrooms across the state 3 years on. Not for lack of evidence of racial disparities in our criminal legal system, not for lack of trying to highlight and upend these disparities. Each court victory has been hard fought, as Evan will share next, and has had to overcome resistance from prosecutors, from judges, and I would say, most of all, from an entrenched faith in the system. In the US Supreme Court's notorious 1987 decision in McCleskey, the divided majority by 1 vote rejected compelling statistical evidence that Georgia's implementation of the death penalty was racially discriminatory in violation of the Constitution. Justice Powell's majority opinion noted the risk that would have been associated with accepting that Georgia's application of the death penalty was racially discriminatory. McCleskey's claim, taken to its logical conclusion, throws into serious question the principles that underlie our entire criminal justice system. If we accepted McCleskey's claim that racial bias has impermissibly tainted the capital sentencing decision, Justice Powell wrote, we could soon be faced with similar claims as to other types of penalty. Moreover, the claim could be extended to apply to claims based on unexplained discrepancies that correlate to membership in other minority groups, and even to gender. Justice Brennan, in dissent, famously recognized this fear for what it was, a fear of too much justice. As Justice Brennan wrote, the prospect that there may be more widespread abuse than McCleskey documents may be dismaying, but it does not justify complete abdication of our judicial role. The California legislature, in enacting the RJA, expressly rejected, for California at least, the standard that the US Supreme Court set in McCleskey. Yet the effective implementation of the RJA will require a similar confrontation of the fear of too much justice. I'm honored to be joined here with Evan, whose work has already been recognized before he's gotten up here, a public defender on the front lines who's had 2 foundational RJA victories, and it is true there are not that many of them, so those are very important and demonstrate what is possible. And Sean, my co-counsel and friend, who's trying to make sure that the work in the legislature and the courtroom is grounded in the needs of community members affected by racially disparate prosecutions in Orange County. I'm going to talk about some work that we have been doing at the ACLU to force prosecutorial transparency and accountability across the state, and the significance of this work to RJA implementation and hopefully long-term structural change. Why does transparency of prosecutorial data and policies matter? Prosecutors, as we all know, have extraordinary authority to determine whether and how to charge, to determine whether someone is likely to be in custody or not while they defend themselves, to make a plea offer, recommend a sentence, or diversion or dismissal. It's thus really important to know, do prosecutors even have charging policies? Or are individual prosecutors left to their own devices, their own discretion, their own biases? And what does the data show about how prosecutors are exercising their extraordinary authority to affect the lives of members of our community? I'll also talk briefly about some of the challenges that we've identified and efforts to address those challenges. In Penal Code 745A, as we've discussed, the RJA identifies 4 types of violations which can require a judicial remedy, where an individual involved in the case demonstrates bias or animus towards the defendant. 2, where there is bias or animus in court during the proceeding. 3, where there are disparities in charges or convictions. And 4, where there are disparities in sentences by race of the defendant or by race of the victim. A1 and A2 claims are based on identification and elaboration of racial animus on or off the record, statements made and found in a police report, trial transcript, or other context. These claims are obviously, as has been discussed today, not without their challenges, including most notably reading between the lines, as racist language is often very coded. We are very far from this now, but I would guess that over time, prospective A1 and A2 claims may become less common. This may be naive, time will tell, but it seems easier to hide racist language, some of the explicit or implicit biases that could be present in a courtroom. We've been devoting significant attention on confronting the unique challenges in A3 and A4 claims. These may be harder to win, we'll see, but here also the systemic racism is harder to hide. Any A3 or A4 claim requires both facts and analyses that extend far beyond the record of the case. Defendants must answer and judges must consider, what is a more serious comparable offense? What is similar conduct? Who are similarly situated individuals? What is the evidence that establishes the disparity? One significant limitation in the RJA is also that for a data-based claim, it is necessary to have some county-level data regarding racial disparities. But that data is very often in the hands of the state, prosecutors, law enforcement, and the courts. And as we've discussed, the RJA has only one very limited discovery provision, where Penal Code 745D requires the disclosure of all requested evidence relevant to a potential RJA violation by a motion upon a showing of good cause. Here, as was discussed earlier, I think in the first presentation, we have one early, hard-fought, very important victory, where the Court of Appeal in 2022 in Young recognized that the good cause showing for mandated disclosure of information relevant to an RJA claim pursuant to Penal Code 745D must be low, a plausible factual foundation based on specific facts that a violation could or might have occurred. The Court of Appeal recognized that lowering the bar to access information about the disparity was one of the ways that the RJA was supposed to change the status quo. Quote, preventing a defendant from obtaining information about charging decisions without first presenting that same evidence in a discovery motion is the type of catch-22 that the Act was designed to eliminate. That question is still not definitively answered. While last week's Court of Appeal decision in Mosby is a decisive win, as Soo-Jung was describing earlier, it must be recognized that the petitioner there presented 3 specific expert reports and analyses of the disparate application of the death penalty in Riverside in order to win a 745D motion, not the ultimate evidentiary hearing, just the right to access discovery. They also presented comparative examples of white individuals with lesser charges in order to win a 745D motion. They did not contend that that was necessary. They rejected that that was necessary, but they presented it. And the court did not say that this was required, very importantly, in the final decision, but it did consider them in finding a prima facie claim. Also of critical importance, the Court of Appeal in Young rejected the view, which had been advanced by the prosecutor and the Attorney General, that a court cannot consider racial disparities in arrests. In order to access information to seek to prove his ultimate RJA claim, the petitioner in the case, Clement Young Jr., presented not just statistical evidence of the racial disparities in drug prosecutions, but also racial disparities in arrests, and specifically evidence that racial bias may have played a role in his own arrest. Mr. Young is a black man whose arrest was initiated by a police officer who deemed him suspicious merely because of the way he was looking at other officers while at a gas station. The officer followed Mr. Young and identified minor vehicle-related violations as cause for the stop. Then, despite a total lack of resistance on the part of Mr. Young, the officer used force to conduct the arrest. Again, the prosecutor and the Attorney General thought that that was irrelevant. The Court of Appeal found that information about bias or disparities from the law enforcement officer or in arrests, not just from prosecutors and in charging decisions, is relevant to an RJA claim. And this must be true. Any other reading would require a court to ignore the well-documented, widespread, and egregious racism in policing practices. Evidence of a racially biased police stop and initial arrest will infect the integrity of a charging decision and subsequent prosecution. Despite this important ruling, there remain significant hurdles even to access sufficient county-level data to succeed in a 745D discovery motion, as all the practitioners in this room well know, as well as, of course, to succeed in a 745A3 or A4 claim. Our RJA champion, who is up next, Assemblymember Kalra, sought to remedy this with AB 2418, which the ACLU was a sponsor of, passed into law in 2022, which would require prosecutors to collect various critical data points and provide these data points to the California Department of Justice. And it would require the California Department of Justice to publish this data anonymized in a form that would allow for analysis. This will be of critical importance when meaningfully implemented because of the requirement that the data be published, but even more foundationally, because of the requirement that the data be collected in the first instance. There is no prosecutor in the state that currently collects all of the information that AB 2418 will require them to collect. Some prosecutors don't even collect or can't produce or won't produce information about the race of the defendant. For obvious reasons, an A3 or A4 claim is impossible without data that can demonstrate disparities by race. Many prosecutors assert that they do not collect data about the custody status of defendants at the time of conviction, or about whether defendants have been offered or granted diversion, or the plea offers provided and whether they've been accepted. Penal Code 13370, as implemented by AB 2418, would change this. However, the law will not be implemented without adequate budgetary appropriation. So one call to action is to make that happen. In the meantime, without any mandated proactive disclosure obligations, we have the state's public records law as a primary tool to access the information needed to give life to the RJA. Since soon after the RJA's entry into force, the ACLU has partnered with the law firm of Braun, Hagee, and Borden in a massive statewide effort to get data, policies, training materials, and RJA-related communications. And even though Chesa stole my thunder, I will take the opportunity to publicly appreciate Braun, Hagee and also to apologize to them because I don't think that they realized the magnitude of the effort when they signed up. And also, critical to the success of this effort have been phenomenal Berkeley law students who have helped to get us access the information and are now also helping us analyze it, including Hope Gardner, who's been doing phenomenal work with Braun Hagee, and now the Berkeley Criminal Law and Justice Center. We publish the records that we receive immediately to facilitate their use by people facing the heavy hand of the criminal legal system, by their defense attorneys and family members, by academics and the general public. Some prosecutors ignored us for months until a lawsuit was filed. Others Others responded, but in responding, demonstrated serious misunderstandings of their obligations under the state's public records law. Orange County was one of those. Before we filed suit, along with the Peace and Justice Law Center, represented by their executive director and my co-counsel and co-panelist here, on behalf of the local organization Chicanos Unidos and the ACLU, OCDA took the indefensible position that they were not obligated to extract and produce prosecutorial data. In response to what I call a meta PRA, seeking information about the district attorney's response to PRA requests since the RJA was implemented, we found that OCDA stopped producing any prosecutorial data in response to any PRA request from any requester. They had routinely responded to requests for prosecutorial data through mid-February 2021, and then in late February 2021, 2 months after the entry into force of the RJA, this abruptly stopped. In response to every subsequent request for information from journalists, people in custody, public defenders, and others, Orange County DA Todd Spitzer asserted that it would not extract and produce any prosecutorial data. This about-face was memorialized in a March 2021 email in which an employee wrote to the district attorney's public information officer, quote, "Going forward, we will not prepare records that are not already in existence in response to a Public Records Act request." The email redefines data extraction requests as among those which the DA would interpret as requesting information not in existence and thus not obligated to be produced pursuant to the PRA. This position did not hold up in court. Indeed, as soon as we filed the case, the DA abandoned this argument completely. Bear in mind, they had used it for dozens of requests, in response to dozens of requests over a more than 2-year period. But they didn't completely abandon their position. They shifted to other arguments about why they should not be compelled to produce prosecutorial data. A judge in an August 2023 tentative ruling indicated that he would ultimately reject their arguments and require the production of anonymized prosecutorial data. The suit is ongoing, with issues still to be resolved, including regarding the DA's non-disclosure of certain policies and training materials. But the district attorney has now disclosed the data to us that they had withheld for years, and similar data to the public defenders. Moreover, the Orange County litigation has resulted in the DA's transformation from one of the most recalcitrant DAs to one of the more transparent, dare I say. This is from their website that says that they are now committed to an effort to promote greater transparency and accountability. Their about face did another about face. Soon after disclosing the prosecutorial data to us in litigation, they began producing it, although in a way that may be indecipherable to a layperson, but still extraordinarily important. The prosecutorial data that they now readily disclose on their website, I will say starting from 2000, so 23 years of prosecutorial data, is some of the prosecutorial data that would be proactively disclosed by all DAs if the Justice Data Accountability and Transparency Act is implemented statewide. And a challenge to all of you, if your county is not at least as transparent as Orange County, there is work to be done. On our side, we have our eyes on other DAs with a persistent misunderstanding of their obligations to disclose public information about what they are doing in our name, with our resources, and to our community members. Meanwhile, as highlighted by the last panel on data and some of the comments after it, and some of the conversations that we've been having on the sidelines, there are fundamental questions about how to use the data that we and others have been able to access. And there is a wide chasm of knowledge and expertise between criminal defense attorneys and data experts. For data disparity-based RJA claims to succeed, we need to bridge this chasm. There are exciting conversations happening to answer big questions, and obviously to raise more questions. What types of offenses are ripe or appropriate for A3 and A4 RJA claims? For instance, are there sets of statutes that effectively operate as more serious offenses for similar underlying behavior? What would the criteria be to establish this equivalence? What data is available that could be used to reliably measure disparities as required by the RJA? What are the best data sources to use for different questions? How might the various data sources that exist be used complementarily? What data, and as discussed in the previous panel, how much of it is needed for some of the questions that we need to have answered? What is the appropriate comparison pool in analyzing charging and sentencing disparities connected to particular conduct? Or what should the denominator or starting point of the analysis be? What are the types of analysis best used for calculating disparities in different contexts? What are the advantages and risks of each one? And how do you avoid adopting or incorporating police biases and disparities into your analysis? I will never take linear algebra, but I will also never say that I'm scared of math again. But there is a need. There is a need for continued engagement, dialogue, and creativity for these claims to be crafted and for them to be successful. And we're grateful for the work of researchers who have begun to do such analysis. In addition to some of those in the room today, I also wanted to shout out and recognize a collaboration between University of Wisconsin-Madison researchers Mike Light and Jung-Young Kim that they've been doing with the coalition to implement the RJA. These researchers have access to over a decade of California criminal history data, CORI or ACHS data, which I actually think is much harder to access than Professor Bird had identified, but maybe she can give us some hints about how to access it. That data is typically under lock and key and inaccessible to people seeking to make RJA claims. Again, if that's not true, let's prove it. Let's make that happen. And obviously, this is the work that Colleen Chen and Bill Sundstrom and others from the Paper Prison Initiative are trying to make that more accessible. The researchers don't, on their own, have an understanding of the questions that need to be answered about how the criminal legal system operates and where disparities might exist, but they do have the expertise to analyze the data, which people facing charges, their families and defenders and advocates lack. So through this collaboration, Professor Light, with the assistance of Mr. Kim, have begun to produce fact sheets analyzing racial disparities at the state and county level in arrests, charging, convictions, and sentencing for certain offenses that may be appropriate for data-based RJA claims. For example, they found that Black people are almost 4 times as likely to be arrested and 3.5 times as likely to be prosecuted as white people for resisting arrest. And in some counties, the disparity was particularly severe, with Black people more than 12 times as likely to be arrested for this offense as white people. Black people were even more overrepresented when looking at the standalone charge of resisting arrest, where an individual is charged for resisting arrest without any underlying offense for which they would otherwise be arrested, an offense which I would venture to say is nonsensical. Black and Latinx individuals were also more likely to be more severely charged, where prosecutors have discretion to charge resisting arrest as a misdemeanor or a felony. They were more likely to charge Black and Latinx people with a felony for the same offense. In a forthcoming fact sheet, they're looking at the arrest for and prosecution of marijuana cultivation and possession for sale. And among other findings, they note that while absolute arrest and charging rates decreased overall and in all racial groups since Proposition 64, when California legalized the use and sale of marijuana, disparities in the arrest for and prosecution of these offenses has increased. The potential of the RJA is massive. The ongoing and increased collaboration between those affected by the criminal legal system, those defending people within it, and those trying to make sense of the disparities with analytical skills is essential for this potential to be realized. Each small victory, which is not so small, in a courtroom contributes to what we hope will be a meaningful snowball effect, where the cascade of justice and the unraveling of systemic racism in our criminal legal system will be palpable and growing. Dare we dream it will be unstoppable? Individual cases demonstrate proof of concept. It is possible to reject the fear of too much justice, to implement the principles that undergird the RJA. So too, we hope will be the case with greater access to and analyses of data about racial disparities and policies related to charging decisions and the manner in which prosecutors prosecute cases. Data has the power to demonstrate how individual decisions made every day in response to or in the absence of policy combine together to create systemic injustice. The existence of policies, training, guidance documents shows what prosecutors care about, how they use their resources, whether and how they take steps to protect against explicit or implicit bias. The lack of such policies, training, and guidance is also meaningful, including to the extent of unconstrained prosecutorial discretion. As has been really powerfully highlighted today, including really notably by I think all of the defenders in the early morning practitioners panel, The threat of the RJA also can and should have a really transformative deterrent effect. So our snowball today may be small enough to melt in our hand, but I am really inspired by the skills, power, and energy in this room. It makes me optimistic that that will not be the case for long. Thank you.
Good afternoon. My name is Evan Kuluk. I'm a Deputy Public Defender at the Alternate Defender Office in Contra, Costa County. And this afternoon I'm going to do a mini deep dive into the litigation in the Eric Wyndham case. I am so humbled by several shout outs earlier today. This RJA defense community has been just an incredible support system. There's folks that I've been meeting with on a regular basis for 3 years, collaborating, strategizing, and supporting each other. So I don't take full credit for any sort of victory. Incredible work of interns, colleagues, all sorts of folks who have put this all together. So I represent a young African-American man named Eric Wyndham. And Mr. Wyndham is part of a 4 co-defendant case alleging homicide, murder charges, including gang allegations and multiple special circumstances. So as charged, he's eligible for life in prison without parole. And spoiler alert, in May of 2023, we got a ruling under the RJA finding that the charging of the gang murder special circumstances violated the RJA in Contra Costa County and got that enhancement dismissed. I wanted to start with a screenshot from the news story on it. Ali Saidi, who's in the back of the room, is featured here. This is actually from a protest outside the courthouse around the time that the decision was coming down relating to, the protest was relating to some extreme and expansive racist text messaging by the Antioch Police Department that was uncovered. And depending on how much time I have, I'll get to that at the end of this talk. I love this headline, but it's full of lies. The judge did not find that the DA's filing practices are racist. In fact, I never used the term racist in any of that litigation. I never used the term racism. That is a highly charged, highly loaded word, and it's not something that our judges need to find in order to grant our Racial Justice Act motions. And if we use that kind of terminology in court, we're gonna build up those defense mechanisms from the prosecutor, from the judge, and hurt our chances of success. So let the media call it racist, that's fine, but it's not language that I'm gonna use. The other part of this headline is dismissing gang charges. Well, that's partially true, but what was dismissed here specifically was the gang murder special circumstances, not all gang charges. And there was a fantastic question earlier this morning about using the RJA to challenge the entire gang penal code statute. It absolutely is racist, and all gang charges, all gang enhancements have had significant racial bias. But in this particular circumstance, what I did was really hone in on one specific area where we could find clear disparity. Call it a test case, if you will, as we developed what can we actually develop as this similarly situated group where we can find these statistics and it will just be clear and simple. And it's hard because it wasn't a complete win. My client is still charged with other special circumstances. He's still facing life without parole. I don't want to pretend that this was more than it was. We still have an incredible battle ahead of us, and we're challenging other things in other ways. But this was litigation to see, can we get a judge in the face of clear numbers to do the right thing and issue a ruling? So starting with the basic premise, which has got to be based on the anecdotal experience of the people who practice in your county. And the public defenders in Contra Costa have witnessed disproportionate charging of black clients with gang allegations and with special circumstances. We've seen it, we know it. So let's dig in, let's get the data and see that statistical proof of what we've had with that anecdotal experience. And so what I focused in on was what I called gang-related murder cases. And this was, again, to have an achievable analysis. Because what we have is a major point of prosecutorial discretion. In charging gang-related murder cases, prosecution can charge first-degree murder with the 186.22b standard gang enhancement. This carries life with possibility of parole. Or prosecution can charge first-degree murder with the 190.2a22 gang murder special circumstances. This carries life without parole. This is a huge, huge decision. Is this person worthy of a chance at seeing a parole board? And what we've seen in Contra Costa and across the state is special circumstances being charged more and more and more. And after the advent of youthful offender parole, special circumstances being charged more and more against young people who would be eligible for youthful offender parole unless they're convicted of a special sentence to LWOP. And it's used as a leverage tool to extort pleas out of young individuals who can't take the risk of going to trial facing LWOP. So we've got this major point of prosecutorial discretion, and the challenge here under the Racial Justice Act is to define that similarly situated group, the 745A3 challenge that we're making. And so what we did was we used a combination of Public Records Act requests and the 745D motion to get the data from the district attorney's office to figure out who's in this similarly situated group, who are the individuals charged with gang-related murder for whom that prosecution discretionary decision would apply. And ultimately, we ended up with 89 total defendants in this data group, gang-related murder charges between 2015 and 2022. And as Alex Carney was talking about earlier, the reality of Racial Justice Act litigation is we have small data sets. There's not going to be tens of thousands of people charged in this kind of circumstance. So one issue in this litigation is the prosecution's response was, your data set's too small to have any meaningful statistical significance. That was a challenge that we faced. The retort here is, the prosecution only gave us these 7 years of data because it was in 2015 that the Contra Costa DA's office switched from basically a paper system to a digital case management system. And so in response to the public records requests, they were willing to provide that data that they could do from running a search in the digital case management system. So that's what we had. We were limited to that time period, but it was 7 years of scope. And ultimately, the judge found that was enough to do our analysis. Also, as Alex mentioned earlier, when you were talking about data sets that are this small, 89 individuals, you can't do a complex regression analysis. The kind of statistical analysis that we can do is something that practitioners, you can understand. Law students, we can all do this. I'll talk a little bit more about how we approach the statistics in court as we go forward. So, of these 89 defendants that we identified charged with gang-related murder in Contra Costa County, that included both those who were charged with murder and the standard gang enhancement, as well as murder with the special circumstances carrying LWOP. And we set the similarly situated group define race here based on the DA's data, just comparing black versus non-black. And the language of the Racial Justice Act says, defendant is charged more seriously than defendants of other races. And so that is an appropriate analysis. It does not have to be black versus white. You look at your numbers and the circumstances of your county, and in this case, it made the most sense to look at black versus non-black. So we want to think about population of the county. Contra Costa County is about 9.5% African American population. And of those 89 defendants charged with gang-related murder, 48 out of 89 were black defendants. That's 53.9%. So we're not even getting into that discretionary decision of LWOP versus life. Just purely looking at who's being charged with gang-related murder, we have an extremely disproportionate amount. And this is kind of the starting place that we looked at the raw numbers and then continued to dig in. I also wanted to think about outcomes. Even though we were not bringing a sentencing challenge, because we were bringing this challenge pre-trial, we didn't want to wait for my client to be sentenced to LWOP. We want to get this taken care of now. I looked at that just general gang-related murder charges, where we have 54% of those charges being against black defendants in Contra Costa County. And then I got prison data, public records request to CDCR, and we asked for all individuals serving LWOP sentences in cases out of Contra Costa County with gang murder special circumstances. And there were only 10 individuals that came back in that result, but 7 out of 10 were black. So we start with this extreme disparity of overcharging 54%. When we follow through to who's actually being sentenced out of Contra Costa County, we go all the way to 70% black defendants. I looked at statewide data for corroboration. We use this in our prima facie pleadings, and the 2020 report on the Committee of the Revision of the Penal Code had some great data analysis of CDCR numbers for individuals serving time on gang charges, and an appendix that broke it down by county. And of course, we needed to be presenting county-specific data. So according to the Committee on the Revision of the Penal Code, the data that they had, which was sort of extensive from CDCR, so 24% of people serving prison time in California for gang enhancements are black. That's the statewide data. Out of Contra Costa County, 48% of people serving prison time in California in cases arising out of Contra Costa County for gang enhancements are black. So Contra Costa is sending twice the statewide average of people to prison with gang enhancements for black defendants. So then I wanted to break down this point of discretion in charging, looking at those LWOP charge decisions versus the life with possibility decisions in gang cases. So looking in our middle column here, murder with the standard gang enhancement, a slight majority of those individuals, 19 non-black, 18 black. But then when we look at just the raw numbers here, who's charged with murder with the gang murder special circumstance, 30 individuals, black, and 22 in the non-black category. So this is basically what I was able to get to on my own is, okay, I see a very clear numerical disparity, but I need help understanding this and analyzing this. And so I worked with UC Irvine professor Dick McCleary, who's here today from the School of Criminology. And he helped me understand the data. And ultimately, the kinds of analysis that we did were fairly simple mathematical analysis. But Professor McCleary was helpful in letting me understand what is the most effective way of expressing this disparity that we see. And Professor Fagan mentioned a a few moments ago, this idea of the odds ratio, and that's the tool that we used. And so what I want to go through here is sort of a concrete illustration of using that odds ratio. Professor Fagan said, you can do it. It's pretty straightforward, and it's something that the judges could even understand. All right, so we wanted to separate out black defendants and non-black defendants. Of black defendants, 62.5% of black defendants charged with gang-related murder were charged more seriously with the LWOP, Special Circumstance Enhancement. Of non-black defendants, 53.6% were charged. So everybody, across races, there is more than a majority of people being charged with special circumstances in Contra County. I mean, that's a problem alone, right? Special circumstances, supposed to be reserved for the worst of the worst. These are people who, the government is deciding should never get a chance at rehabilitation. It should not be a majority of cases, despite any race issues. But that's the data that we had over 7 years. But here we have, just our sort of base percentage disparity, black versus non-black, of those LWOP charges. And so then focusing in on getting our odds to build our odds ratio. What we want to look at is what is the odds that a black defendant accused of gang-related murder will be charged more seriously with the gang murder special circumstance. And that's simply building the raw numbers. We have 48 total black defendants alleged to have gang-related murder charges, 30 out of 48 with the LWOP enhancement. It's simple division, 30 out of 48 divided by 18 out of 48. That gets our odds. And so for black defendants in Contra Costa County, the odds of a black defendant being charged with that more serious special circumstance is 1.666 repeating. And then we compare that to the odds that a non-black defendant would be charged with that special circumstance in a gang-related murder charge. And that got us an odds ratio of 1.1578. All right, so then we get to this concept of the odds ratio. It's also sometimes referred to as relative risk. What's the risk of one thing happening versus the risk of another thing happening? And Professor McCleary was able to testify at the evidentiary hearing and educate our judge that this is a preferred method of measuring racial disparity that's used by statisticians, it's scientifically accepted, and it's regularly used to evaluate data sets. The odds ratio is used to test significance and to rule out chance. And so what we ultimately wanted to get to was, what's this odds ratio here? In Contra Costa, over the 7-year period, what's the risk of being charged with gang murder special circumstances for black defendants relative to the risk for non-black defendants? And the math is easy. We divide one odds by the other odds. So the odds ratio is the odds for a black defendant being charged with the gang murder special circumstance divided by the odds for a non-black defendant, and we get an odds ratio of 1.4395. And basically what that means is black defendants are about 44% more likely to be charged with gang murder special circumstance facing LWOP than non-black defendants, all who are similarly situated as having been accused of gang-related murder. We had the evidentiary hearing, and the prosecution presented a accountant who is there, like an in-house accountant in the DA's office, who mostly works on white-collar cases, crunching numbers for fraud. They sort of saw their different view of the case. What they presented to the judge was, well, if you look at the percentage of black defendants with LWOP in these gang murder special circumstances case and compare it to the overall rate of charging gang murder special circumstance, then the disparity is just not that big. It's not barely there. Well, of course it wasn't, because they put all the black defendants on both sides of the column. So they completely shrunk the disparity by including black defendants in part of the overall group. So you weren't comparing black versus non-black. You're comparing black versus a comparison group that was still majority black. That was kind of the statistical defense. The prosecution also presented a number of senior attorneys in the office to talk about their charging practices and why they charge certain gang cases certain ways, to explain that that they didn't intentionally use race in making those charging decisions. The court ruled that we had established a significant statistical disparity, and it's a significant disparity that was a statistical disparity. It wasn't required that we presented a statistically significant disparity. Semantics, but that's important. So we established the statistical disparity that more likely than not is correlated and caused by the defendant's race rather than random chance alone. And we had the burden to prove by preponderance of the evidence. So just only that more likely than not standard. And when we did establish that statistical disparity, the district attorney didn't offer alternative race-neutral explanations for the disparity in charging. They simply presented prosecutors to say, we're not racist. And so the court dismissed the gang murder special circumstance in the case. We brought this pre-trial, and that's important because there's a serious concern that if we wait until after trial, and if there's a conviction and a true finding on a special circumstance, then the judge may not have the power to strike the special circumstance even after an RJA finding, based on the language in 745E that says notwithstanding any other law, voter initiative, and voter proposition that prohibits a judge from striking or dismissing special circumstance. This is all just to say we had to do this ahead of time. It's important. Everyone should be thinking about not waiting for trial, not waiting to say, well, let me try to beat the case and not have to worry about this. That's great, and do beat that case, but litigate this beforehand on specials issues. How am I on time? Okay. So Penal Code Section 745, Subdivision H, I just want to kind of remind these important factors to be educating our judges about the language of the statute and what is or is not required. Again, statistical significance in that sort of scientific term is not required, just a significant disparity that is probably based on statistics, but it does not require that term of art. Once we have established that significant disparity, then it really is a burden-shifting situation. And this is something that Judge Goldstein's decision really explained quite clearly, and his written decision should be in the MCLE material, so folks are welcome to read that, and it truly is a great roadmap of talking through this. But it's clear that we established that significant disparity. The burden then is on the prosecution to establish race-neutral reasons. And this idea of digging into specific facts about particular cases and how many defendants were in one, or what color the car was for the drive-by, those are the kinds of sort of micro facts that the DA has been trying to bring in many cases, and that's simply not required. As long as we are able to define that similarly situated group and show that statistical disparity, we've met our burden, we've done our job, and it's on the prosecution to do that deep dive into cases and try to find some justification for the charging that's based on these race-neutral reasons. Because the prosecution did not do so, they failed to defeat our showing. So as I mentioned in the evidentiary hearing, multiple prosecutors testified, and in advance of the hearing, as we were sort of building up to the hearing, based on a moment of genius inspiration from Lisa Romo, I sent a Public Records Act request to the DA's office asking for all written or formal policies, guidelines, procedures, trainings that they have regarding prosecutorial filing decisions in murder cases for the determination of whether or not to file special circumstances. And we got back a response from that public records request: no such materials exist. So in going into the evidentiary hearing, these prosecutors testifying, I knew that in my cross-examination I could ask them about this. And for each one, I asked this question: does the Contra Costa District Attorney's Office have formal procedures, policies, guidelines, or training for making this decision of filing specials? And the answer is no. So what we're talking about is this incredibly weighty discretionary decision. Am I seeking life or LWOP? And there are no criteria or guidelines. And the court, in its ruling, the judge found that the DA's office lacked a best practice guidelines for avoiding implicit bias in charging, and that was an important piece of the decision in making the determination that our statistical disparity showed that it was a correlation with race. The discretion without guidelines is the structural issue here. So I wanted to just say a few things on this topic to make this, sort of pull this back from the statistics to the structural idea. Prosecutors' offices need to have safeguards, guidelines to make those incredibly important filing decisions without implicit bias, or to reduce implicit bias. The 2021 report of the Committee on the Revision of the Penal Code found that special circumstances could have been filed in 95% of all first-degree murder convictions, right? So it's a discretionary decision that basically the prosecution can almost always file it in any case that's a first-degree murder. Looking at prison data from that 2021 report, looking at who's in prison right now, black defendants are here in red. So 34% of people serving prison sentences for first-degree murder are black, but 42% of people serving felony murder, LWOP, are black. So that's some statewide data that shows that effect of those discretionary charging decisions, whether to bring special circumstances, and the impact that it has on who's serving those sentences in prison. There's been some good research on implicit bias in terms of discretion without guidelines being prime for implicit bias. UCLA Law Review article, Implicit Bias in the Courtroom, talks about circumstances of discriminatory behavior. Well, the conditions under which implicit biases translate most readily into discriminatory behavior are when people have wide discretion in making quick decisions with little accountability. And there's another great article in Seattle University Law Review by Robert Smith and Justin Levinson. Professor Levinson's been doing some great work assisting folks with RJA litigation that talks a little bit more, and that article is called The Impact of Implicit Racial Bias on the Exercise of Prosecutorial Discretion. So taking my talk into that structural piece, which is the title of the panel, this litigation in the Wyndham is a strong illustration that prosecutors must establish written policies with objective criteria for filing decisions to determine when, if ever, to seek LWOP in homicide cases. If not, we're going to continue to see a pattern of implicit racial bias impacting those decisions, and who's in prison and serving those sentences is a clear illustration. So I don't have time to get into the Antioch racist texting scandal, but I'll talk about that another day.
Thank you so much, Evan. And next we have Sean.
Hey, everybody. So you've all been sitting so perfectly for an hour. If anybody wants to stand up for a second or stretch, I know I'm grateful for a chance to come up to the podium. It's been a long hour. I mean, it's been a great day, but yeah, I just want to give people opportunity to do that. So I wanted to start my talk with a quote. Normally, every Friday morning, I am lucky to start my day with a meeting of an organization called the CAYCJ, which is an amazing group. We're usually about 40 people on our calls, and it's half lawyers and half impacted people. So it's an incredible balance of opinions and diverse feelings. And we always start with either burning some cedar or reading some poems or sometimes a song. And I think it helps connect from us as individuals, which I hope to connect to by inviting you all to stand up, to where we fit into the most broad, big picture we can. So this quote does that for me. It's a quote from one of my mentors, Father Greg Boyle, who I'm sure many of you are familiar with. In, I believe I forget which book this is from. I think it's from Tattoos on the Heart. He writes, "We must widen the circle of kinship. We imagine no one standing outside of the circle, moving ourselves closer to the margins so that the margins themselves will be erased. We stand there with those whose dignity has been denied. We locate ourselves with the poor and the powerless and the voiceless. At the edges, we join the easily despised and the readily left out. We stand with the demonized so that the demonizing will stop. We situate ourselves right next to the disposable so that the day will come when we stop throwing people away." And I know that so many of you are public defenders that you understand that this is, in the biggest scale, I think, the most important part of the work we do in criminal defense is hopefully going to a point when we no longer think of anybody as disposable. This quote has another meaning to me, which is something that I struggle with a little bit, which is part of me wants to always have the largest impact possible for the most people. So in Orange County, that is Chicano, Latino, Hispanic, however they're described. That's the group that is most significantly affected by the criminal justice system in terms of raw numbers. But when we look at the details, even though African Americans, black people make up a small portion of Orange County, they are overwhelmingly more affected in terms of structural disparities. And so that this reminds me that if we focus on anti-blackness, if we recognize that particular category of racism in our work, we're actually moving the ball forward for everybody. So I appreciate that. Tell me if I'm right about this. When you say we're going to look at statistics of black defendants versus all other defendants in the category of gang murders, the flip side of that is really we're talking about brown people are actually disproportionately less likely to get it. Is that right?
In Contra Costa.
Yeah. So I bring this up because I think that is something that is worth making explicit in our work. Okay, so this panel started out being about impact litigation. And I and all of us said, well, we don't actually do impact litigation in the Racial Justice Act arena. And I've always been very critical of impact litigation, going back to before I was an attorney. I was a high school teacher, and I was involved in some big impact cases. And we won a settlement, and the attorneys claimed victory. But I looked at my classroom, and I never saw any changes at all. In fact, I saw some negative effects in some cases. I had less discretion in how to spend my budget on books because I had to buy textbooks instead of classroom library books. So I've always been a little critical of impact litigation, which is not to say I don't think there's a place for it. I still have a dream in my mind of a taxpayer action against the district attorney where a judge enjoins them from any prosecutions that would violate the Racial Justice Act, which I don't see why not. So I do have impact litigation sort of plans, stirring in my eye, or in the back of my brains. But I found that the approach that resonated with me is movement lawyering. That's impact litigation can be a part of movement lawyering, but it's a much bigger, broader approach. And I think the Racial Justice Act is particularly important for movement lawyering because it is the Racial Justice Act, the legislation, right, comes out of a movement for racial justice and criminal justice, and it was only the movement that made the passage of the RJA possible. And so all of the work that we're doing now is really work that is the benefit of the movement, and that benefit should go back to the movement as well. So I want to talk about movement lawyering, and I wanted to start with a definition of movement lawyering. I'm sure some of you are familiar with the concept, the idea, but we also have a lot of, I'm trying to think of how to say this. I don't want to insult anybody by referring to public defenders' offices as bureaucratic institutions. And none of you, I would never want to dismiss any of you as bureaucrats, but you know what I'm saying, right? I spent some summers in public defenders' offices, and I saw that there was not a lot of systemic support for people who wanted to do things like movement lawyering work. Anyway, so here's the definition. Movement lawyering is the mobilization of law through deliberately planned and interconnected advocacy strategies inside and outside of formal lawmaking spaces by lawyers who are accountable to politically marginalized constituencies to build the power of those constituencies and to produce and sustain democratic social change goals that they define. So there's a lot in there, right? But I just wanted to highlight, and I did highlight a couple ideas of interconnected advocacy strategies. So that's what I just talked about in terms of impact litigation is one, but there are a lot of other strategies. There's litigation, there's helping individual clients, there's organizing, right? We heard from Morgan in the Ella Baker Center about organizing behind the bars and the importance of that. So interconnected advocacy strategies, which just doesn't mean a lot, it means interconnecting, working together. Also accountable to politically marginalized constituencies. And what I want to key in that is not just accountable to your client. It is very easy as lawyers, we're trained to be accountable to our individual client. But the idea of being accountable to a politically marginalized constituency is a much more difficult process, especially working in a place like Orange County, where there is not a really clearly defined movement with movement leadership. I worked for a while in LA, and there's no end of movement leaders in Los Angeles. But right, it's just the opposite in Orange County. And many of the counties you're working in are somewhere in between. And then the last thing is to build the power of those constituencies. I want to highlight that because this is, I think, one of the hardest things to do in criminal defense, which is how do you build power for a movement when you're so focused on your individual client? So those are the ideas that define movement lawyering. And it raises the question, though, what movement? So I mentioned in Los Angeles, there's no end to the number of movement leaders, right? And we see fragmentation. And so we see, one group that claims that they're Black Lives Matter, another group claiming there's some other part of the movement for Black lives, and they're disagreeing. And you've got people calling each other out. And in the middle of that, most attorneys are like, I don't want to go near that mess. They're all throwing things at each other. I don't want to get hit by any of it. But that's no excuse, right? We still have to dive into that world. And we have to, in times when there is no clear movement, we have to help build the movement. So that's really where the Peace and Justice Law Center, where I work, we find ourselves, is how do we partner with organizations and build them up? So there has to be a movement to do movement lawyering. That's not easy. Having national movements, having statewide movements is not enough. You have to have local constituencies you're working with. The next questions to come from movement law, once you answer that, is a set of questions that are really challenges to attorneys. The first one is, does this work divert political challenges into legal challenges? In other words, is the fight against racial injustice in our criminal legal system, is that a legal challenge or is that a political challenge? Obviously, it's both. But in our work, are we shifting it from political to legal? And the problem with that is it would disempower movement building. Right? If the movement has to wait for you as an attorney to solve a legal problem while they twiddle their thumbs, the movement's not going to build. The second question is, does it emphasize individual rights over collective action? Again, when you're working in a criminal defense context, your client comes first, right? So the individual rights of your clients are always paramount. But thinking about collective action is important. So we heard from Courage earlier. I see somebody with a Courage jacket in the back. We heard a little bit about participatory defense, Silicon Valley Debug. We have in Orange County the Rapid Response Network. I find a lot of public defenders uncomfortable working with participatory defense hubs. But that's part of a way of responding to this challenge for movement law of emphasizing collective action, not just individual rights. Third, does it confuse rule change for social change? Thinking in the Racial Justice Act context, what if we were to solve this problem? What if we were to have racially neutral prosecution decisions, but everything else about racism in society stayed the same? Right? Would we have one? So if your approach would end with perhaps winning an end to racial disparities. All right, so I think I was on the last question of my critical questions I'm borrowing from Scott Cummings' article. The last one is, does the approach empower lawyers to make crucial political decisions without accountability to the constituencies they purport to represent? So we've heard a lot about strategic thinking that goes into deciding how to frame questions, how to do the research, how to present data, and recognizing that there are potentially winners and losers in some of these choices we make. Are we being as inclusive as possible with movement actors in making those choices? So these are the critical questions. And then in addition to the thoughts I just shared about each of those questions, I think they sort of imply that there is a role for movement lawyers to play in the RJA context. And those are first, to mobilize movement actors to build political will for continued amendments to the law. I can't wait to hear from Assemblymember Kalra about the future of the Racial Justice Act. I suspect that there's a sense that we need a few more published opinions and the political winds to start blowing in the other direction again for us to make some amendments that will make this a more effective tool. But those are never going to happen. And in fact, the political winds are never going to reverse without a movement. The second is making racially equitable prosecutions a normative expectation. So by normative, in this case, I mean normative for the whole system. And that includes the general population, right? People have to have a normative expectation. They just believe, of course, prosecutions are supposed to be racially equitable. Of course, this is America. We believe in equality here, equal protection of the laws enshrined in our Constitution. Right? But that has to be more accepted as people's general beliefs in the community than the opposite, which is we all get treated as individuals. We should look at every case as an individual. And if the net result at macro forces is racist, well, that's not what we're really supposed to be looking at. So it's the movement for racial justice and criminal justice reform that is going to change those normative expectations. And I'll talk a little bit in a minute about some practical ways that we can contribute to that. The third value I think movement lawyering can bring in the RJA context is ensuring broad implementation beyond public defender clients. So there is, like we heard earlier from Morgan, there are jailhouse lawyers out there who need support and are doing really good work in their institutions. There are people who just want to represent themselves or are trying to get to a place where they've got habeas lawyers. There's also the private criminal defense bar. So there are a lot of people outside the public defenders that are going to need support and don't have the resources to act as a large body of lawyers the way public defenders' offices do. Basically, Lisa Romo has been doing amazing work getting us all to work as a collective, but not every criminal defense lawyer in California is part of her groups. So there's another area. And then last is to assess effectiveness. I was just having a conversation outside right now about AB 333, which was a bill that was passed and written by a bunch of people who are here in this room today, got passed. The author was Shirley Weber, who did amazing work, but now she's our Secretary of State. She's not following up on this. Oh no, it's Cam Logger. Sorry, Cam Logger, my bad, who is now in Congress and not following up on this. So it's incumbent on someone else, in this case, hopefully the Peace and Justice Law Center and a group of grad students at UCI, to figure out whether or not that bill made any difference at all. So we need folks outside the criminal defense bar to assess the effectiveness of these things. And these are all things where movement lawyering organizations can help. Okay, so I want to spend the last couple minutes talking about how this has played out in Orange County. And the first piece of work we did in Orange County was to try and build an initial coalition. So we reached out to Chicanos Unidos and the Orange County Rapid Response Network and the ACLU and about a dozen other organizations. And we brought folks together to start having conversations about, do you know this law exists? Does this play in at all into your strategies? How can we make some synergies happen between this as a legal reform and their work as movement organizers? The next was to assess the situation. Now, at the time when we first started this work a year and a half ago, we looked at what was going on with the Orange County Public Defender. And at the time, it was just getting a discovery motion responded to was impossible. There was no way to get any of the data, it felt like, at the time. So we decided, well, that data is the first step. So we filed, along with the ACLU, the lawsuit you heard earlier against Todd Spitzer, demanding a complete copy, anonymized, of the DA's case management system. And that's been successful. So the next step now is we've got to do something with that data. But yeah, things keep moving, so you've got to keep reassessing the situation. But that was where we started. Yeah, so the first campaign is get the data, get the money. There are actually two other things I want to bring up right here. First, with the assessment of the situation is we also heard from a lot of people saying, I have a family member who's doing 25 years. I think he has a Racial Justice Act claim. How can you help me? And the answer at the time was, well, we can't yet, but we can work together and stay close, join the meetings, and as soon as we have support for you, you'll be first in line for it. But I had actually not at first been thinking about the retroactive claims and participatory defense hubs. And so that was one of the first things that we added to what I was bringing to the table when we first got together. And the other thing was money. So we right away started talking to the organizations that are advocating for a more humane budget in Orange County at the county level with the county supervisors, and convinced all of them that adding some money for a full-time Racial Justice Act attorney was something that just had to be in the budget if the supervisors wanted to continue to get the support of any of our organizations. Now that turned out to be a little bit of a touchy political question, and the public defender in our county said, whoa, careful, don't go advocating and getting into our budget deal when things are going, we've got plans too. So it's always important to make sure that we're balancing both movement demands and the work of insiders. But the end result is we ended up with a budget that does now include a line for Racial Justice Act work. So that was another exciting early win that shows what we were capable of. And now the next step, I think, is test cases. So our approach at the Peace and Justice Law Center is always to start at the most grassroots level with individuals as possible. Most of our work involves opposing counterproductive gang suppression. So we work with as many people as possible who are involved with gangs or maturing out of gangs, so we can see how does any possible policy change really would it impact their lives. So the same thing with this. So what we need to find in our next step, I think, is, like I brought up earlier, how do we do the most good for the most people? How do we find some test cases? Who are the right defendants for test cases? What is replicable? And what I've always got in the back of my mind is the idea that there are certain charges for whom there are thousands of people who are currently serving time based on convictions in Orange County alone that should have that time reduced under the Racial Justice Act. Or there are certain charges, and the first ones that came to my mind are criminal contempt for violating a gang injunction statute that just should not exist under the Racial Justice Act. So how do we need to choose some things like that? Oh, resisting arrest when there's no other crime charged. So we need to take a look at those. And the body of data we need is not just what we can get from these data requests. The body of data we need also involves reading maybe 5,000 arrest reports once we get them. Like big, large-scale, in-depth reviews of facts where we're coding all of these things and creating our own data on all of the potentially race-neutral reasons, able to do our regression analyses, and just for ourselves, understand really at a detailed, objective, statistical, factual level, where are the most racially disparate factual problems happening. So that's all work that we're seeing as the next step. And we'll see how it goes, right? We barely started. We need to finish this data case and win some attorney fees so that we have some money to hire somebody to help us with all of this data work. So it's all been very slow going, but this is where we are right now. I think all I had left was I wanted to, wrap that up. So I tell you all of this as hopefully if you're in Orange County to work with us, and if we're not already working together, everybody at the table over there I'm familiar with. If you're outside of Orange County, look for people who can partner with you who are taking this approach, because I think, as I said before, there is some value to partnering outside of the usual criminal defense bar with movement organizations and movement lawyers. And I think that the long-term health and success of all of our work really depends on it. So, if you want to get in touch with me, here's my contact info. And thank you all for listening and not dying in a fire.
Thank you so much to all of you for attending, and a final round of applause for our amazing panel.